Welcome back. Today we're diving deep into a very important topic for HR professionals, workplace accommodations under the ADA. Whether you're new to HR or you're a seasoned pro, understanding the ADA is crucial for fostering an inclusive and compliant workplace. I believe that compliance with laws is the absolute baseline, the bare minimum an employer should do. I believe that in order to have really great employees, you have to be a really great employer. In order to do that, you probably should do a lot of things that are well above what the legal requirement is. But this video is really going to talk about the bare minimum that you need to be compliant with the ADA. Let's start with the basics. The Americans with Disabilities Act, or the ADA, is a federal law that was enacted in 1990. It prohibits discrimination against individuals with disabilities. This includes employment, ensuring that people with disabilities has the same rights and the same opportunities as everybody else has. When job applicants or employees request job modifications, the law requires us as employers to provide reasonable accommodations. That's changes in the way things are usually done. We need to provide these accommodations to job applicants and employees who have impairments that substantially limit a major life activity, unless doing so would cause an undue hardship for the employer. Now, we'll talk later about what an undue hardship is. A reasonable accommodation can help a person with a disability apply for a job, perform the duties of a job, or enjoy the benefits and privileges of employment overall. If you have 15 or more employees, this is including state and local governments, employment agencies, and labor unions, you are required to comply with the ADA. This means that if your organization falls into one of those categories, you need to be aware of your obligations under the law. Now, I'm certified in California, so it always comes to mind to make sure to specify that you need to check your state, especially California, for more restrictive requirements. We are going to cover 5 topics today. First, what is a disability under the ADA? Second, the types of accommodations. Third, the interactive process. Fourth, undue hardship. And fifth, we'll talk about the consequences of noncompliance. First, let's clarify what the ADA defines as a disability. The ADA states that a person with a disability is someone who has a physical or mental impairment that substantially limits one or more major life activities, has a history or record of such impairment, such as cancer that's in remission, or is perceived by others as having such an impairment. This could be something such as a person who has scars from a severe burn or something to that effect. Understanding this definition is crucial for identifying when an accommodation may be needed. What does major life activities mean? Major life activities are the kind of activities that you do every day, including your body's own internal processes. There are many major life activities in addition to the examples that I'm going to list next, but these are just some. Actions like eating, sleeping, speaking, and breathing. Movements like walking, standing, lifting, and bending. Cognitive functions like thinking and concentrating. Sensory functions like seeing and hearing. Tasks like working, reading, learning, and communicating. And finally, the operation of major bodily functions like circulation, reproduction, and individual organs. You might be wondering what type of disabilities are covered under the ADA. Some disabilities are visible and some really are not. A few examples include cancer, diabetes, post traumatic stress disorder, HIV, autism, deafness or hearing loss, blindness or low vision, epilepsy, mobility disabilities such as those requiring the use of a wheelchair, a walker, or maybe even a cane, intellectual disabilities, traumatic brain injury, and there are many more in addition to those that the ADA covers, so this is not an exhaustive list. Next, let's talk about the types of accommodations. Workplace accommodations can vary widely, really depending on the needs of the employee or the applicant and the nature of their disability. Some common accommodations may include modifying the work schedules. This would be to allow for medical appointments or for them to manage fatigue. It may include adjusting workstations to make them accessible. An example of this would be providing ergonomic furniture or some sort of assistive technology. It could also include job restructuring. This might involve redistributing non essential tasks that an employee finds difficult to perform. Now, let's discuss the interactive process. This is a collaborative dialogue that you should really have with an employee or an applicant to determine what a reasonable accommodation may be. In some instances, the appropriate accommodation is obvious, and therefore it's really not necessary to go through a step by step process. For example, you have an employee who uses a wheelchair and they request that the desk be placed on blocks to elevate it above the arms of the wheelchair. If you can comply with that, an appropriate accommodation's been requested, identified, and provided without the need for a formal process. However, if an accommodation isn't that obvious, an appropriate accommodation is best determined through a flexible interactive process. As part of this process, the EEOC recommends that you, one, analyze the particular job involved and determine its purpose and essential functions. Two, to consult with the individual with the disability to better understand the precise job related limitations that's imposed by the disability and how those limitations could be overcome with a reasonable accommodation. And third, in consideration with the individual to be accommodated, identify potential accommodations and assess the effectiveness each would have in enabling the individual to perform the essential functions of that position. And finally, consider the preference of the individual to be accommodated and select and implement the accommodation that would be most appropriate for both the employee and you as the employer. I recommend 5 steps to ensure compliance with the interactive process. The first step is initiation. The employee requests the accommodation or the need becomes apparent. It's very important to be able to recognize a request because, according to the EEOC, an individual can use, they call it plain English, and they aren't required to mention the ADA or they aren't required to use the phrase reasonable accommodation or accommodation for that matter. Therefore, anytime an employee indicates they're having a problem and that problem's related to a medical condition, be sure to consider whether the employee is making a request for an accommodation under the ADA. An example of a reasonable accommodation request would be something like Jane talks to her supervisor and she says, "Hey, I'm having trouble getting to work at my scheduled starting time because of medical treatments that I'm undergoing. Now, this would be a request for a reasonable accommodation under ADA. However, an example of a request that is not considered a reasonable accommodation would be, say, Joe. Joe tells his supervisor that he would like a new chair because his current one is really uncomfortable. Although it's a request for a change of work, his statement is really insufficient to put the employer on notice that he's requesting a reasonable accommodation. Now, why is that? It's because he doesn't link the need for the new chair with a medical condition. Do you see the difference in those two examples? The first one is linked to a medical condition, and the second one is not. It's just a preference. He's just uncomfortable. Two is communication. Both parties should discuss the employee's limitations and potential accommodations. Start this by identifying the limitation and the problem that it causes. Understanding this connection is critical for finding an effective accommodation. Be sure to gather information from the employee whenever possible, as they are well versed in their own limitations and they're going to know which accommodations are likely to work best for them. Once you have pinpointed the limitation and the associated problem, you can now begin exploring accommodation options. You should really be open to new ideas and approaches. Using this stage to brainstorm and consider potential solutions. The employee who requested the accommodation is going to be a really valuable resource, and they should be encouraged to suggest ideas of their own. If additional suggestions are needed, you can definitely consult with the employee's medical provider. Be sure that you get authorization from the employee first, but the medical provider might be able to offer effective accommodation ideas, or they may be able to provide insights on whether a proposed solution will actually address the employee's limitations. The third step is assessment. This is where you, as the employer, will assess the feasibility and effectiveness of the proposed accommodation. After exploring various options, you must decide which accommodation to implement. If multiple options are available, you should consider the employee's preference. However, you do have the right to choose among the effective options, including potentially selecting the lowest cost accommodation. I understand sometimes employers have a fear that trying an accommodation will commit them to it permanently, but that really isn't the case. You can test an accommodation and you do have the right to discontinue the accommodation if it's ineffective. In order to manage this process, you might consider drafting a written agreement with the employee, which outlines the trial period for the accommodation and the steps that would be taken if it proves to be unsuccessful. Now, this will ensure clarity and will prevent surprises when the accommodation is reviewed later. The fourth step is implementation. Once an accommodation has been chosen, it is crucial to implement it effectively. Proper implementation is really key to the success of the accommodation. If equipment's involved, ensure it's correctly installed and that the employee is trained of its use. If the accommodation requires a schedule change or a policy modification, be sure to inform the relevant managers or supervisors so they can facilitate the change effectively. If an outside service is involved, ensure it's provided promptly and effectively. In case of reassignment, allow the employee time to adjust to their new role. Communicate only with essential personnel about the accommodation. Be sure to adhere to ADA confidentiality rules and inform managers and supervisors only if it's necessary. The fifth and final step that I recommend in the interactive process is follow up. Regular check ins are essential to ensuring the accommodation remains effective and to make any necessary adjustments. Monitoring accommodations after they're implemented is a critical yet often overlooked part of the interactive process. Accommodations may stop being effective for various reasons, such as changes in the employee's limitations, workplace equipment, job duties, or the workplace itself, or because the accommodation becomes an undue hardship for the employer. Due to these potential changes, you should periodically review the effectiveness of the accommodations. If equipment's involved, be sure to assign somebody to perform necessary maintenance or upgrades on it. Encouraging ongoing communication is the most important way to monitor accommodations. Employees should be informed to report any changes or issues with the accommodation, and they need to know who to contact. Remember, the key here is to engage in an open and ongoing dialogue. It's about finding the right solution that works for both the employee and you as the employer. Now, let's address undue hardship. This term refers to an accommodation that would be too difficult or too expensive to provide considering the employer's size, financial resources, and the nature of the operation. It's important to note that proving undue hardship is a high bar and it can't be based on speculative or minor inconveniences. Finally, let's talk about the consequences of non-compliance. Failing to comply with the ADA can lead to serious consequences. This can include legal action by the EEOC, lawsuits from employees, and significant financial penalties. Even worse than any of that, it can damage your reputation and it can really hurt employee morale. Just remember, if you're doing the right thing, then it's ultimately going to save you a lot of money. You will have better employees in the long run. To recap, understanding and complying with the ADA is not just a legal requirement, but a commitment to creating an inclusive and supportive workplace. By knowing the definition of disability under the ADA, the types of accommodations, engaging in the interactive process, understanding undue hardship, and being aware of the consequences of noncompliance, HR professionals can ensure they're supporting their employees effectively and legally. Thank you so much for watching. If you found this video helpful, be sure to give it a thumbs up and subscribe to my channel for more HR tips and insights. If you have any questions or topics you would like to cover, be sure to leave a comment below. Until next time, keep fostering those inclusive workplaces. Bye.